Good afternoon. My name is Wendy O'Brien, and I'm going to be your host today. I'm an interviewer and moderator from the International Festival of Authors this year. Welcome to everybody who is here, to the delegates from the conference going on today called The State of Inequality, Social Justice Under Siege, as well as to those of you who are visiting the International Festival of Author. We have a wonderful speaker today. I can't wait to hear what she has to say. But first, please let me introduce to you IFOA's director, Jeffrey Taylor.
Good afternoon. I would like to begin by acknowledging the traditional keepers of the land on which Toronto was built, the Mississaugas of the New Credit, the Huron-Wendat, the Anishinaabe, the Haudenosaunee, and any other acknowledged and unrecorded nations who have cared for the land. Hello, as Wendy mentioned, I'm Jeffrey Taylor. I'm the director of the International Festival of Authors. I'm very delighted to be here with you this afternoon. Some housekeeping things. At first, I would like to ask you to silence all your devices that you may have that might tweet, beep, or make any other kinds of noises. That said, we are a social media friendly festival, so I encourage you to share your thoughts on social media using the hashtag IFOA2017, and also feel free to tweet at HLA_IFOA. Please be mindful that flash photography is not permitted, though we encourage you to take pictures. For those of you that have been at other IFOA events this week, you know that the festival continues to support PEN Canada and all the wonderful works they're doing to free writers who have been silenced. An empty chair appears on every IFOA stage to represent writers who are unable to attend events such as this. Pictured here is the writer Rashid Razmanov. Mr. Razmanov was arrested on May 9th, 2013 and sentenced to 9 years in prison on charges of illegal possession and sale of drugs. PEN believes the charges against him were politically motivated, and they call for his immediate and unconditional release. If you would like to support PEN's advocacy, please sign the petition outside this theater. By signing this petition, you give PEN Canada a stronger voice to lobby against such injustices. On behalf of the IFOA, I'm very delighted to welcome you to what is now the 4th annual interdisciplinary conference presented by the Humber College School of Liberal Arts and Sciences in association with the International Festival of Authors. As you know, this year's conference explores the current and past states of inequality and social justice from a multidisciplinary perspective. Today's keynote and the discussions throughout this weekend are all centered on these very timely themes. I do hope you enjoy the thought-provoking seminars and discussions that are on offer. Thank you for being here.
Intelligent, thought-provoking, committed, challenging, generous, courageous. These are just some of the adjectives used to describe the work of our keynote speaker today, Susan Herman. Herman received her BA in philosophy from Barnard College and a JD from New York University School of Law. She holds the chair as Centennial Professor of Law at Brooklyn Law School, where she currently teaches courses in constitutional law and criminal procedure and seminars on law and literature and terrorism and civil liberties. Herman was elected president of the ACLU in October 2008 after having served on its National Board of Directors for 20 years, as a member of the Executive Committee for 16 years, and as a General Counsel for 10 years. She writes extensively on constitutional and criminal procedural topics in both scholarly works as well as in other media. Her most recent book, Talking Liberties, The War on Terror and the Erosion of American Democracy, was the winner of the 2012 IIT Chicago-Kent College of Law Roy C. Palmer Civil Liberties Prize. Today she'll talk with us about the current turn towards authoritarianism and its threat to democracy in her address titled, A Republic If You Can Keep It. Please join me in welcoming Susan Herman.
Thank you, Wendy, for the introduction, and thank you all for the invitation. I really appreciate being here. Now, of course, as people who think about social justice, you might think that one reason I appreciate being here is that it's nice to be out of my country for a while where there's a major fight on, in case you haven't heard. The ACLU, which I'll tell you a little bit more about today, has been actively engaged in our 98th year in fighting a lot of what the Trump administration has been doing. By our count, so far since the inauguration, we have brought 109 lawsuits. So we've been really very busy, and those lawsuits range from after 1 week after the election, we got the first injunction against the president's travel ban, the Muslim ban, in which he tried to restrict who's coming into the country. So that was 1 week after the election. And we brought a number of other lawsuits against the administration, including a challenge to his ban on having transgender people in the military, a challenge to undercutting the contraceptive coverage of the Affordable Care Act by decimating that, basically. Literally 109 different lawsuits. So I'm happy to talk about a lot of the work that we've been doing, mostly during the Q&A, and I'm going to refer to some of it as we go along. But as Wendy was saying, I thought that as a theme for today, I chose the title because I thought it was worth talking about not only how individual civil liberties and individual issues about social justice are now under challenge, but how I see a lot of the challenges that we're up against now as being really pretty fundamental challenges to the rule of law and to the premises of democracy altogether. So where I want to start as a student of the United States Constitution is I want to sort of start with some of the structures that were put into place in our Constitution by the founders who were trying to prevent the turn to authoritarianism that we're now worrying about. Some of those structures are very sound, some are flawed, and some it turns out we're finding out more about the flaws as we go along. But I think pretty much all are under attack today. So I was starting with, you may recognize the quote as being a quote from Benjamin Franklin. You recognize this nice portrait of Benjamin Franklin with John Addams, who is seated, and the second president, and Thomas Jefferson, the third president. And after the Constitution was signed, the story goes that Franklin ran into a woman who said to him, "So, what is it that you've just done? What have you just created?" And Benjamin Franklin said to her, "A republic, if you can keep it." So one of the principal ways in which the framers of the Constitution, including the people you see here, thought to protect government against authoritarianism was the first provision in the Bill of Rights, which is the First Amendment. And you can see, if you look at the Bill of Rights and what it covers, the First Amendment, you'll see there are a number of different thoughts here about the idea that we do not live in an autocracy, that we live in a place where every individual person has the free exercise of religion and the right to choose their own religion. And part of that, the first part, is that Congress cannot adopt an official religion. A lot of the United States people who came there initially were coming in to be able to exercise freedom of religion. So after establishing that right of conscience, the right of the individual to decide on their own religion, the amendment goes on to say that the government cannot prohibit abridge the freedom of speech. We also have the right not just to believe what we believe and exercise our religion, but we have the right to speak about what we think. The press has the right to speak, and the right of the people also to peaceably assemble and petition the government for a redress of grievances was also considered to be central. Now, Thomas Jefferson said at one point, and I think this is a great quote, "Were it left to me to decide whether we should have a government without newspapers or newspapers without a government, I should not hesitate a moment to prefer the latter." Okay, so that's what our third president had to say about the press. Our current president takes a very different tone. If you look at the quote in the middle, this is quite a recent one. "It's frankly disgusting the way the press is able to write whatever they want to write," Trump said in response to questions from reporters. And these are some of the tweets about the president referring to any member of the press, any article that's critical of him or any news source, as fake news unless they're being complimentary. And the idea that maybe the government should be able to do something to prevent, quote, fake news, to prevent criticism, unfortunately is not a new idea in American history. So I want to take you back to 1798, when John Addams was president, and Congress passed what was called the Sedition Act of 1798. They passed a number of laws in 1798, and part of this was to prepare for what was expected to be imminent war with France. So they were trying to make sure that everybody was going to be loyal and that there weren't disloyal people in the country. There were alien acts in addition to the Sedition Act. So as you can see, what the Sedition Act said was that you can't write, print, utter, or publish, or cause it to be done any false, scandalous, and malicious writing against the government of the United States, etc. Now, pretty vague, right, what you're going to consider to be false and malicious. And if you read into this, your President Trump's reaction to what's fake news, you have a pretty good idea of what can happen here, because it happened after the Sedition Act of 1798 was put into place with the support of John Addams. There were 25 prosecutions under the Sedition Act, and 10 people were convicted. And the president, John Addams, and the Congress at the time were Federalist. They were one party. It was before we had any exchange of parties in our country. And at that time, all of the Supreme Court justices were also people who had been appointed by Federalist presidents, so they were all essentially Federalists too. And they were the ones who sat and presided over the trials that were brought under the Sedition Act. So one of the most famous examples of a prosecution under the Sedition Act was Matthew Lyon. He was in Congress. He was a representative from the state of Vermont. And just one of his many things that he had to say, he was very outspoken and published various articles. And in one, he accused President Addams of an unbounded thirst for ridiculous pomp, foolish adulation, and selfish avarice. Sound familiar? So, just to give you a sense that the hyper-partisanship and toxic atmosphere in the American Congress today is also nothing new, here is a reproduction of Matthew Lyon disagreeing with Roger Griswold, who was a Federalist, on the subject of whether it would be a good idea to enact the Sedition Act. So they're actually having a brawl here on the floor of Congress. Well, so Lyon was prosecuted for violating the Sedition Act and was found guilty, not surprisingly, if you have complete control over the trial, the prosecutors, everybody else, not unlikely that you're going to find people guilty. Of the 25 people who were prosecuted, most were of the opposing party. Most were journalists and newspapers who were Republican, who were trying to talk people into voting for somebody different the next time. So Lyon went to prison. While he was in prison, he actually ran for re-election from prison, and he decided he wanted to write an account of what was wrong, how scurrilous his prosecution had been, and he also wanted to talk about the prison conditions. So the first thing that happened was they wouldn't give him a pen, so that he couldn't write anything. Ultimately, he did get a pen, and he managed to publish his own account from while he was in prison. Now, what's very interesting about this whole period is that you would think that with all these prosecutions, that would have caused Republican journalists to stop, insulting the president. Well, it didn't. It caused more Republican publications to be set up. And there was a great deal of criticism of John Addams and what he was up to until 1800, 2 years later, when Thomas Jefferson was elected president. Now, Jefferson, who had been a really strong opponent of the Sedition Act, he just thought it was a really terrible idea, pardoned anybody who was still in prison, and the prosecution stopped, and in 1802, the Sedition Act was actually repealed. So, you would think that the United States might have learned that a Sedition Act is not really consistent with the First Amendment, but nobody had ever said so. It was just the political process that caused the United States to move on. So, during World War I, here's another Sedition Act that is enacted in 1918. And this is a similar idea. You're not allowed to willfully utter, print, write, or publish any disloyal, profane, scurrilous, or abusive language about the government or about the military. So you may know that World War I was not an entirely popular war. So there were a number of people speaking out against the war and against the draft. And at the same time, there was a movement. There were a lot of anarchists and communists in the country who were talking about the form of government and beginning to be very critical about that. So what happened with these people? This is history that's not familiar to a lot of people in the United States, but there were prosecutions of a number of the people who spoke out against the government, etc., under the Sedition Act. One example, Charles Shank is somebody who publishes this pamphlet, which you can see it says, "Long live the Constitution of the United States. Your liberties are in danger." And his theory was that the 13th Amendment, which prohibits essentially slavery, which prohibits indentured servitude or slavery, was inconsistent with the draft. Okay, it's a theory, and nobody else agreed with him. But he was prosecuted and he was convicted of a crime. So there's a lot of this going on during World War I, the idea that in time of war, dissent is intolerable, and you're disloyal, and you should be prosecuted for a crime if you speak out against what all your neighbors disagree with. So in 1920, the ACLU was founded, and one of the chief reasons it was founded was that there were a lot of people getting together in 1920 who just really disliked the idea of anybody being able to tell you what to say. And it was a kind of a strange mixture of political and other bedfellows. Roger Baldwin, who you see to the right there, refers to himself as the principal organizer, and he became the first executive director. He had been a conscientious objector during World War I. And he and Crystal Eastman, a woman who was a lawyer, were working at the Americans United Against Militarism. And what they were doing was counseling people who were conscientious objectors and really trying to defend people's right to disagree with what the government said or wanted them to say. Baldwin was so sincere about his objection to the war that he ended up spending a year in prison because he would not even serve the alternative service that he was offered as a possibility to get out of serving in the military. 1920, you might know, is also the first year when women got the vote. So there were a lot of people who had been working on the suffrage movement, and the ACLU founders included a great many women, including Jeanette Rankin, who was the first woman to be a member of Congress. She was the one who got to read the text of the 19th Amendment, giving women the right to vote, on the floor of Congress because she was the only woman there. Jane Addams, the famous social worker, Helen Keller, don't have to tell you who she was. So all these different people liked the idea that people should be able to speak. And they were worried during World War I about conscientious objectors and others disagreeing with the war or the government. But there was also a lot of attention to labor organizers and other people who were having a hard time getting to express their points of view. So one of the first things the ACLU did was to publish this pamphlet called The Fight for Free Speech, explaining why it's important to defend the right of everybody to say whatever it is they have in mind, even if you disagree with it. Now, the other thing that's surprising to many people is that around the time of World War I and in 1920, when the ACLU was founded, the courts were not at all sympathetic to the argument that they should dismiss prosecutions of people for saying what they wanted to say. So the ACLU spent many years litigating. Here's Anita Whitney in California, who spoke out on, she was a kind of labor organizer and spoke out, and she was prosecuted by the state of California, 1927. Here's Angelo Herndon, who believed that the best chance for the United States to get over its history of racism was the Communist Party. So he ended up being imprisoned, and his autobiography, Let Me Live, was published while he was in prison and while the Supreme Court was debating his future. So the courts still were not rising to the idea that the courts should be protecting people's First Amendment rights. And so the ACLU kept litigating, and the most remarkable case to me in 1943 involved these two little girls who lived in West Virginia. They went to a public school in West Virginia, and they declined to pledge allegiance to the flag. And the reason that they did this was that their parents were Jehovah's Witnesses. And the Jehovah's Witness belief is that you can't pledge allegiance to something, a physical symbol, it's like an idol, because that kind of allegiance, that kind of respect is only due to God, and that this was really kind of trying to give to the government the authority that should only belong to the Lord. So what happened when Marie and Gathy refused to pledge allegiance to the flag, because it's what their parents taught them, was they weren't allowed to go to school because they weren't pledging allegiance to the flag, and their parents were prosecuted for the fact that they were being truant. You kind of catch-22 there. So when the case got up to the Supreme Court in 1943, in the middle of World War II, the Supreme Court held in a 6-3 decision that in fact these little girls had a constitutional right under the First Amendment to decline to salute the flag. And Robert Jackson, who later became the chief prosecutor at the Nuremberg trials, said, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein." So this is really remarkable, and to me, this is really a sign that the corner has turned, and that the courts now recognize that they have a role to play in protecting people's freedom of speech. So one saying that we have at the ACLU, and you can see we have the merchandise to back it up, is that dissent is patriotic. So when people complain that Charles Shank or the Barnett girls or the people who are disrespecting the president are not being patriotic, we think quite the converse. So that idea really stuck in the courts, and the United States Supreme Court, if there's any amendment that they really like, it's the First Amendment. And they've often been criticized for going too far in the direction of really protecting people's rights to say whatever it is they think. So since World War II, the ACLU has had a number of areas in the First Amendment where we've worked, and one of the most important is the application of the First Amendment in cyberspace, to the internet. This is an example of a case that we brought, the Child Online Protection Act, which said, you can't put anything on the internet that might be, harmful to children or that wouldn't be appropriate for children. We won that one. We have many, many cases involving students who end up being punished in school for putting messages on the internet, criticizing their teachers, just saying things that the school doesn't particularly like. And we've also been active as to net neutrality, et cetera. So the First Amendment and defending the freedom of speech has been a very central thing to what we do. So Roger Baldwin would be proud, because that's a picture of Roger Baldwin speaking. He also very much enjoyed his freedom of assembly. And what he liked to do, in addition to wanting to censor speech that was critical, a lot of people in the government didn't really like the idea that somebody would stand up on a soapbox or on a car, as Baldwin sometimes did, or on a street corner and start saying things that were critical or rabble-rousing. So what Baldwin liked to do is in situations where he knew he was likely to be arrested because he didn't have a permit and was going to be standing on a car speaking to a crowd, he liked to read out the text of the First Amendment because he thought it was really ironic to be prosecuted for reading out the protection of the freedom of speech. So that's Roger Baldwin. One thing that Roger Baldwin liked to say also, which I think turns out to be very true, is that no civil liberties battle is ever permanently won. So things come and go. So here is a really... seems to be stuck. Okay, I have my little thing. Okay, there. This is a really nice ad that somebody had sent us, and we just thought it was a great idea. So this is a picture of Times Square. Do I dare try to play the video? What do you think? Is it going to play? We'll give it a minute, and if it doesn't play, I think it's not going to want to play. Well, there is a little video here. You can see it on YouTube. It's called The Constitution is for Everyone, and it's only about a minute. And you may be able to see that what this is that was in Times Square is it's the First Amendment, and it's in 3 different languages. And you could have seen it if I could show you the video. But it's first in English, and then it's in Spanish, and then it's in Arabic. Isn't that nice? The Constitution is for everyone. So is there anybody here who thinks that that's an obnoxious message or divisive or controversial? Well, we have a lawsuit going on right now against the Metropolitan Transit Authority in D.C., which ordered us to take that ad down. They have a rule that says you can't put up political ads or things that are too divisive in the metro in D.C. because that's not what advertising is all about. You can't do it. So we are not only defending our right to put up this ad. Isn't that something that's really exactly what Roger Baldwin said, right? You can't put up the First Amendment. Very ironic. So we have a few other people who had also attempted to put up an ad, including the famous Milo Yiannopoulos, the right-wing provocateur. Well, we are content neutral as to speech, so we are representing ourselves, that we have the right to put up our ad, that Yiannopoulos had the right to put up his ad, and people should have the right to put up whatever ads they want, because to us, that's the nature of the First Amendment. You have to be able to say what you want, even though it's critical of government, even though not everybody is going to like the message. Now, you're probably aware that the First Amendment is under some attack these days, and not only from the federal government. There are a lot of people in the United States, and in fact the polling now is that something like 40% of millennials believe that their schools should be protecting them against ideas that make them uncomfortable. So here is Berkeley having serious protests against Milo Yiannopoulos, and a whole lot of, a lot of this is about Berkeley, but many other places where students are taking the position that if somebody wants to come and say things that they find very hateful or uncomfortable, that they shouldn't be allowed to speak. Well, we disagree. We think, again, that people should be learning to deal with speech that they disagree with instead of just trying to censor it. I think that's a very similar reaction to government reaction of, you can say what you want as long as you're complimentary of the government, but you can't criticize the government. Okay, so there are a lot of issues about free speech going on right now, and what is the scope of free speech, and can you really be protected? Will the courts really protect you if you just want to say things that your friends and neighbors don't agree with or find uncomfortable or even hateful? At the same time, we also have a major assault going on around the country about the right of assembly. So here too, there have been some issues about demonstrations. We have a lawsuit going in the District of Columbia courts about the incredibly draconian reactions to people who protested at the inauguration So that was one problem with respect to DC itself. There are 15 states around the country, the ones that are colored blue here on this map, that have introduced legislation that would severely punish protesters and really try to deter protests. Again, these are just proposals right now. They haven't passed. But to give you a few examples, North Carolina has a proposal that demonstrating, having a demonstration on the street should be considered economic terrorism, especially if you're blocking the sidewalk and people can't get to the stores, and have a very heavy fine. In Arizona, there is a proposal that if you help organize a demonstration and the demonstration develops violence, even if you have not participated in the violence, you should be liable to asset forfeiture laws. So even if you didn't know that there was going to be violence at the demonstration and didn't participate in the violence, somebody could come after you and you could presumably lose your house because somebody else at the demonstration had become violent. Now, is this a way to encourage free speech, or is this a thing to do to make people afraid that we'd better not protest? Best of all, in the Dakotas, where we've had the Standing Rock protests, by the Sioux and by other people, they have proposed laws that if you run over a protester with your car, you should not be considered liable because, after all, they shouldn't have been where they were. So, that's challenges to the right to protest. Now, to me, that's, number one pillar of democracy, that you have the right to say things that are critical of the government, you have the right of assembly, you have the right to petition for grievances. And too much shutting down of that, whether it's the federal government or the states, really starts to feel dangerous. So, protection number two that the framers put into the Constitution to try to empower the people to push back, and I think this is very much related. The Fourth Amendment, which is about search and seizure, it creates the right of the people to be secure in their purses, houses, papers, and effects against unreasonable seizures, and says things like, they have to get a search warrant before they can come search you. Now, I always think of this as the Benjamin Franklin's desk provision. All of the framers were, in one way or another, people who could have been prosecuted for some sort of crime. They all had seditious literature. They were all revolutionaries, right? Many of them had been not paying taxes on things like tea or molasses or whatever. They didn't want to pay the taxes. So they really thought that this was about them. They didn't sort of divide the country into the criminals and us. They understood that you can't give the government the power to go search for what's in Benjamin Franklin's desk. And that, to me, the surveillance is very much related to the freedom of speech. Because if you know that the government can come search your desk at any time to see what you've been saying and whether you've been recommending that there be a change of regime or whatever, then first of all, you're going to feel less likely to want to say anything. You're going to feel chilled. And it's just a terrible situation when the government can be in control of what people have to say. So I'm sure you're aware, and this is actually one of the subjects of the book that Wendy mentioned, Taking Liberties, that after 9/11, the government really supersized its surveillance powers. And the idea was we need to know more about what everybody is doing so that we can find the terrorists. Now, there's an entire course worth, I can tell you, because I teach it, in terms of what did they change and how did they change it, and all this stuff about PRISM and FISA and all these different things going on. But I think that this is a fair summary of the new policy. Yeah, and that's the idea. The more the government knows about you, the better, because then they can find the terrorists by connecting the dots. So, since 9/11 in particular, the ACLU has done a tremendous amount of litigation about all these government surveillance authorities, trying to get the courts to say, no, wait a minute, you can't do that. You can't actually go into Benjamin Franklin's desk to find out what he's writing and what he's reading, unless you have a warrant. One of the many programs that there was allows the government to listen to conversations and read your emails and everything else if they believe that they will find foreign intelligence information. So here's a lawsuit that the ACLU brought on behalf of Amnesty International. A lot of Amnesty people in the United States, and they also have their main office in London. So what they thought was that they have a lot of conversations in all different forms across the seas, and they thought that given that they spent a lot of time dealing with people who are political prisoners or children who are enlisted as soldiers by different countries, they thought that the government might well think that a lot of what they're doing is related to foreign intelligence, because the definition of that is kind of broad and you don't need it. So they brought a lawsuit to say, wait a minute, the government should really have to have a warrant. They should have some reason to want to listen to our conversation, because otherwise people are afraid to talk with us about what's happening. Among other people who were challenging the surveillance here and in other cases were journalists, people who said, my sources in the Middle East are drying up, they don't want to talk to me, because they're afraid that if they talk to me by email or phone or over Skype, they might end up on a no-fly list or, a terrorist watch list or, who knows. So, interestingly enough, the Supreme Court just kind of took the courts out of this by saying, well, in order to bring a lawsuit, you have to have standing. And for non-lawyers, that means you have to be able to show that you are personally injured by this law. Otherwise, it's just all hypothetical and not your business. So the court said, you don't actually have standing to challenge a covert surveillance law unless you can prove that you personally are being subject to covert surveillance. Okay, catch-22, right? The whole point of covert surveillance is they actually don't tell you. So the courts just really kind of stayed out of it. They basically said whatever the government wants to do is just fine and did not protect people's privacy rights in the same way that they have come to protect First Amendment rights. So enter Edward Snowden, who has actually told us that one of the reasons that he decided to reveal a lot of the information that he did was after reading that Supreme Court case, he realized the courts weren't going to do anything and that people just maybe needed to know more about what was really at stake. So Snowden is not the only person here who pushed back. Before Edward Snowden's revelations, and these people are covered in my book, there were the librarians in Connecticut who pushed back against an FBI agent who was demanding information about one of their patrons. There is an internet service provider who had to spend 6 years being known only as John Doe in all the litigation because another part of the surveillance regime is that a number of these statutes have gag orders attached, where if the FBI serves on you a national security letter, which you see Nick holding he had this picture taken for my book, dressed up and everything. But what that says in the national security letter, in addition to telling him what information the FBI was demanding, without going to any court, they just write the letter because they want this information and they believe it might be relevant to their investigation. They also instruct him never to tell anybody that he has gotten this demand. Well, Nick, as an internet service provider, and the library connection people wanted to testify before Congress, which was considering whether or not to extend this kind of surveillance authority that was involved here under the Patriot Act. And they were told they weren't allowed to do that because of the gag order. Okay, so what happened to the right to petition for redress of grievances? So this gag order is still very much the subject of litigation. Can the government not only enlist people, third-party custodians of records? How much does your internet service provider know about you? Not only can they enlist them, but they can prohibit them from telling anything about the fact that they've been asked for information. Now, the reason that there are all these black splotches on the national security letter here was that Nick always got that it might be a problem if he told everyone who the person was who was under investigation, because that might actually interfere with a government investigation, who knows. But what he wanted to tell about was the experience of getting a national security letter. So he, amazingly enough, litigated for 6 years to get the right to finally disclose who he is and that he was the person bringing this lawsuit. During those 6 years, it was a very difficult thing for him not to tell anybody that he was involved in this litigation. He said his girlfriend broke up with him because she had the sense that he was hiding something from her. Every time he went to court, he said he had to hide his legal papers where nobody could find them, and he had, just had to pretend that he wasn't involved in this at all. So another current example of a lawsuit is Wikimedia, which is the ACLU's plaintiff in a case against the National Security Agency, which is about whether or not the government can just tap right into the internet and get all sorts of information directly. I was actually in Montreal, a couple of months ago at the Wikimania conference, and people were very excited about this, about pushing back. So people often ask me the whole question about government surveillance. Why should I care what the government knows about me if I haven't done anything wrong? Well, I don't know if you know the organization PEN, P-E-N. It's an American organization, not just American, but the American branch here of an organization of writers, journalists, etc. And they tried doing a couple of years ago a survey among their members to try to find out whether they thought they had been affected by all this surveillance. And if you can read this here, 28% said that they have curtailed or avoided social media activities. Another 12% have seriously considered doing so that's 40% of people who were censoring themselves. 24% answered the question that they had deliberately avoided certain topics in phone or email conversations. Another 9% had seriously considered doing so. And 16% had avoided writing or speaking about a particular topic, and another 11% have seriously considered it. So this was the first attempt that I've seen to try to quantify what is the chilling effect here, and is that real? Does the government surveillance in fact deter people from researching what they want to research? Are you going to take out the biography of Osama bin Laden? Are you going to research how bombs are made if you feel like the government is one step behind you watching everything that you do? Penn also attempted a global survey talking about the impact of mass surveillance on international writers. And there's also, in 2015, Amnesty with YouGov did its own poll on government mass surveillance, asking people in many different countries, assuming that your intelligence agencies are intercepting and storing data from the use of your internet and mobile phone, would you be more or less likely to do the following? And the first question was, would you be more or less likely to criticize the government on social media, email, or private messaging? Now, if you go across Canada, there is the first from the left, so you can see how you measure up there. And then the next question was, say whether you would be more or likely to do the following, assuming, again, that there's interception of data. Would you be more or less likely to search online for personally sensitive or confidential information, such as medical conditions, sexual and reproductive health, relationship advice, etc.? So you can see there, again, the results that some people say, I would be less likely to do that, with Canada there. I thought you might also like this little graph here from Amnesty International, the percentage of people who are against the US government spying on internet and mobile phones. And interestingly enough, you'll see the number one top here is the Germans. They remember the Stasi. The Germans are very concerned about privacy, and they have no doubt that they don't want the government to know what they're doing, even if they don't think they're doing anything wrong. You can see there, fourth from the bottom on this list, but not that low, is Canada. The United States it's been complicated in terms of public polls. So on the surveillance area, I have a quote here that I just think really sums up a lot of the whole idea of what's going on with the Patriot Act, from Elaine Scarry, who teaches English at Harvard. And what she said is the Patriot Act inverts the constitutional requirement that people's lives be private and the work of government officials be public. It instead crafts a set of conditions in which our inner lives become transparent and the workings of the government become opaque. Either one of these outcomes would imperil democracy. Together, they not only injure the country, but also cut off the avenues of repair. Okay, so isn't that, I think it's really profound in terms of this the two sides of this. The government wants to know more about us, and at the same time, they want us to know less about what they're doing. And the argument there, called the Mosaic Theory, that the United States government often uses is, we can't tell you anything about how we're fighting terrorism because then the enemy would know and they might be able to adapt. So we can't tell if we're tapping your phones because then they might figure out how to use a different technology. So in addition to trying to challenge the supersizing of surveillance, and we have had some success in the legislature. There have been a few places where Congress has pulled back at what the government can do, but for the most part, it's not a good situation. At the same time, we've also been working to try to increase government transparency. In the United States, there's a very useful statute, still with us so far, called the Freedom of Information Act. And what you can do is if you want to get the government to show you records of what they have, whatever it is, your record or what are they doing about the environment or whatever, you have the right to get that information from the government unless the government has a good reason listed in one of the exceptions. So if you ask the government for information and they won't give it to you, you can take them to court and you can get the court to say, what's your reason? And then they explain, and then the judge decides whether or not they have a good enough reason to refuse to give you the information. So in the fall of 2001, when we didn't know a whole lot about what was going on, how many people had been detained, we didn't know whether people were being interrogated with harsh techniques, we didn't know if there was torture, we didn't know what was going on. Two young ACLU lawyers, you see here, Amrit Singh and Jamil Jaffer, decided maybe they could use the Freedom of Information Act to try to find out what the government was doing. And a senior lawyer in the office said, oh, come on, that's really naive. You really think that any judge is going to order the government to turn over information about how are you interrogating people or whatever if the government says, oh no, we need to keep this quiet because of national security? He said, oh come on, forget it, you're just so naive. He said, if you do this, I'm going to give you a nickel for every page you actually get. Well, I'm going to tell you that that lawyer had a renege on the bet. Because what Amrit and Jamil got, in addition to other things, was they got the Office of Legal Counsel memos about whether torture is something that should be considered by the president, hundreds of thousands of pages. They actually published a whole book called The Administration of Torture, based on what they found out. So it turned out the Freedom of Information Act was really a remarkable way to do something about government transparency. And again, we're talking here about democracy. The gag order under that was imposed on the Connecticut librarians and the internet service provider mean that people can't push back. If you don't know what's happening, people can't actually debate what should our policy be. And the Freedom of Information Act is the same kind of thing. If you don't know what the government is doing, how do you push back? How do you argue that we should have a different policy and that we should elect people who are going to be doing things differently? So among the incredible number of Freedom of Information Act lawsuits that we have pending right now, there's one that we have pending about local documents on implementation of the Trump Muslim ban. Now, this was something where when the Muslim ban started, we didn't really know what was happening and how it was being implemented and how many people were being caught up in it. So since we have affiliates and a presence in all 50 states, we had coordinated Freedom of Information demands in every state, just asking, okay, what happened here? And we've started to get a lot of information about how the travel ban was actually had been implemented. And there are a lot of places where, it's pretty scary what was happening that nobody would have known if you hadn't put this all together. You can see there are all sorts of other things. We've asked for information about the targeted killing policy. The government declines to issue any statistics telling how many times we send over the drones and who's actually killed and what's happened. So also very, very important. And so the Freedom of Information Act is a very important channel that we have. But again, it's sort of the second pillar of information. We should know what the government is doing. They shouldn't be able to find out everything about us. The third major safeguard that was built into the Constitution to protect us against autocrats was the, obviously, voting elections. And what's very complicated under the initial Constitution is that in order to protect us against all sorts of dangers that the framers envisioned, they established different ways of choosing every branch of the federal government. So in the initial Constitution, the House of Representatives was directly elected by people in the districts in their states. It was by popular vote. The Senate originally was chosen by state legislatures. The state legislature would choose the 2 senators from their state. That wasn't changed until the 17th Amendment, and now the people do get to vote for senators. The judges are appointed by the president, the federal judges and Supreme Court justices, but the president, as you probably know, is elected by the Electoral College. And this is one reason why Benjamin Franklin told people that we are a republic. We are not a democracy. People aren't just elected by majorities everywhere. So the idea of the Electoral College was that each state would appoint, in the manner that their legislature directed, a number of electors that were equal to the number of senators they had, so everybody got 2, plus the number of representatives they have. So you notice already there's a slight thumb on the scale in the same way that the Senate has it, because a very populous state like California, which has, I think, like 63 electoral votes, something like that, is competing with Wyoming, which has a very small population, so the fact that they get 2 senators gives them disproportionate power. And I don't have the figure right with me, but if you're in Wyoming, you have something like 4 times as much electoral clout as if you were a voter in California. So the choice of the Electoral College is an anti-democratic choice, and boy, did we find that out on election night. So here is the electoral map that we saw on election night. Now you may believe, in fact, what all of the polls tell us, which is that President Trump lost by 3 million votes. So if we had a democracy, Hillary Clinton would be president, plain and simple, but we don't. So if you look at the map, the red states are the states that went for Trump, and the blue states are the states that went for Clinton. California, New York are much more populous than a lot of those big states in the middle, like Wyoming and Montana, Texas. And so that means that there's a strong thumb on the scale that favors the rural states over the large urban areas, and therefore tends to tilt these days more Republican than Democratic. Now, a couple of things about this map. This is a sort of a vestige of the idea that the United States of America was a collection of states. Under the original Articles of Confederation, the states made all the decisions. And one of the main things that the Constitution was trying to change from that was to try to give more power to the people. But they hadn't gotten all the way there yet. And so the states still had, as you could see, a lot of power, including the power to choose as states to choose the president. Now, if you scratch back into history, another thing you see about this is that James Madison really liked this idea. He was from Virginia, and the population of the states at the time of the framing of the Constitution was nothing like the population of voters. Only white men with property could vote. Women could not vote. People without property couldn't vote. And what Virginia was all about was that they had a lot of population in Virginia of people who were enslaved. And you may know that in the original Constitution, there was a 3/5 clause that gave Virginia representation that counted 3/5 of the population who just couldn't vote because they were enslaved. So Virginia gains political representation in Congress for people who they don't even consider people, who they will not let vote. Now, I think, from what I've read, I think the Electoral College is also a vestige of that system, and it's really a kind of a pro-slavery system. So I wrote an article about, after the election, the ACLU since the 1960s has had on record opposition to the Electoral College. So this isn't just about Trump. We just think this is undemocratic and it's unequal to people in the different states. And however, if you look back at that map, to amend the Constitution, you have to get 3/4 of the states to agree. Are 3/4 of the states going to agree? It's not going to happen. So there is an alternative. If you're interested, we can talk about it during Q&A, called the National Popular Vote Act, which is also not going to happen anytime soon. But that's part of our problem, that President Trump now is doing things that are not what a majority of the American people favor. If you look at poll after poll, a majority of people don't like the travel ban, a majority of people don't like what he's doing about reproductive freedom, a majority of people don't like what he's doing about the environment, but he doesn't have to care because he doesn't need majority approval. And if you think it's no surprise a majority of people don't agree, a majority of people did not want him to be president. They don't agree with his policies. Okay, so here is another issue. Under the Constitution, as originally decided, it is the states who get to decide who gets to vote, who's qualified to be a voter. And what the framers put in for a kind of protection to make sure that the states didn't engage in too much funny business was they said, whatever you do to set who gets to vote for the most numerous branch of your state legislature, the assembly or whatever you call it, those are the people who get to vote for your representative in Congress. So that means the states get to decide. Well, a lot of states decided, well, we don't need for black people to vote at all, even if they're not slaves. So we've had a few amendments over the years that require the states to be a little bit more equal. The 15th Amendment says you can't designate voters on the basis of race. The 19th Amendment says you can't prohibit women from voting, a few things like that. But nevertheless, the states do get to set qualifications within those parameters. In addition, the states also get to set the times, places, and manners of holding elections, the state legislature. And that means that among the other powers that the states have is they get to decide how the districts are drawn within their state. So if Wisconsin gets a certain number of seats in Congress, then they get to decide how those districts are going to be designed. This particular map is about the Wisconsin State Assembly, and it shows an example of very effective gerrymandering. So what you see here, if you look at the top, you'll see that at the time in 2008, the percentage of Democrats and Republicans in the state was pretty even. If you go down to today, there's now a tip between, a slight tip. Instead of being 56-44 Democrat-Republican in 2016, it was 47-53. So there have been some changes there, which we'll talk about in a minute. But if you look at the discrepancy between the percentage of voters and the number of assembly seats, you'll notice that the number of assembly seats has gone down quite dramatically. So that although with a fairly split vote, the Democrats had 52 seats in the legislature as opposed to 46. They now have, even though that they are 47% of the electorate, they only have 35% of the assembly seats. Okay, and that is, again, it's clever gerrymandering. There's a whole science to do this. You can do it by computer. You figure out how to put all the people who are going to vote for one party in one place and not let them split up. Very scientific. Same thing was done in North Carolina. This is the Republican Congressional Map, and you can see different ways to draw districts that would result in different compositions of Congress. In 2012, every 10 years we have new districting because the census is taken. So if North Carolina has gotten more population and Ohio has lost some, Ohio will get one fewer representative, North Carolina might get one more. So every 10 years the state legislature gets to decide how to draw the congressional districts. Well, when the Republicans took over in North Carolina, the composition in the state of North Carolina was, again, about 50% Democrat, 50% Republican. But since the Republicans have taken over and have done heavy-duty gerrymandering, the composition of the congressional delegation of North Carolina has gone from 7 and 6 to 10 Republicans, 2 Democrats. Okay, so this is a real way to put a thumb on the scale. The Supreme Court has a very important case now pending called Gill versus Whitford, which is going to really test the Supreme Court. There have been a number of cases so far where the Supreme Court has refused to get involved in this kind of partisan gerrymandering. The ability of the people who are in power to use their power to lock out any sort of electoral change. There are a number of other ways in which the states are not that serious about democracy, and Congress, although Congress has the right to do something better, Congress hasn't done it. So, for example, Election Day is not a holiday. Election Day is a Tuesday, and people have to go to work. Okay, so there are a lot of people who have a hard time, especially when there are long lines. They have a hard time because they have to be at work. Another thing that's happened is because the states get to make the rules, states have chosen rules that, again, very much tilt the electorate. So if you think, Wisconsin has gone from 53% of Democrats to 47%, well, I think another thing that you have to ask is why. So this isn't about Wisconsin, but this is about a lot of states. Another thing that happened, and this started during Reconstruction, was disenfranchisement of people who were convicted of crimes. Again, colorful map here about who's disenfranchised. People with felony convictions permanently disenfranchised. You can never vote if you've been convicted of a felony in Virginia, in Florida, in a number of these other states. And there are other states that, in the orange, which disenfranchise quite a few people with felony convictions. Sometimes the states have ways in which you can get your voting rights back, but that's kind of difficult. Now, where this started in Reconstruction was a number of the southern states in particular did not want the majority of, there were a lot of people in the state who had been enslaved, and once they were freed, the white people, to put it bluntly, in Mississippi did not want all the black people to come in and take over all the electoral politics by being able to vote in who they wanted. So it was a very clever system that they had where they had the criminal law working together with the electoral law. So there were statutes like vagrancy statutes that gave the police the right to arrest anybody who didn't seem to have a job or just very vague kinds of things, or they would just arrest people on trumped up charges or whatever. And so we know that our criminal justice system for a long time has been very racially skewed. So the game was, once you get somebody convicted of a felony, then you can also deprive them of their right to vote. You can see here some statistics. 6.1 million Americans can't vote because they've had a felony conviction, and it's very racially disproportionate. 1 in every 13 African Americans has lost their voting rights due to felony disenfranchisement laws versus 1 in every 56 non-black voters. Again, that has a lot to do with the racial skew in the criminal justice system. So, major skew. So had Florida not had the felon disenfranchisement law going back before Trump, Al Gore would have been president of the United States, because it is clear that the electorate would have been different in Florida, and I think it's pretty easy to predict. So one thing that happened in 2012 was that we got our first African-American president in 2008. In 2008, it was the most diverse electorate in the United States history, and then between 2011 and 2012, the next presidential election, there were 27 measures passed in 19 different states to make it harder to vote. What a coincidence. The Supreme Court was not helpful either, but let me show you how some of what we consider to be voter suppression statutes work. If the Republicans, and not that Democrats never did this when they were in charge, they also would try to jigger things so that they would lock in their incumbency, but this was mostly recently been states with Republican legislatures elected after the Obama, or seated after the Obama election. And what these regulations do, there are all different kinds. One is about voter registration. It makes it much harder to register to vote. A couple of states have automatic registration where you don't have to go through something of signing up. But in Florida, the new voter registration requirements were so burdensome that the League of Women Voters decided, although that was always their entire reason for being, that they were going to drop out of registration because they were too afraid to register people because they thought all their workers would be arrested for running afoul of the law because the laws were so complicated. If it's found that people vote early because they have to show up at work or whatever, and that early voting would favor the Democrats, early voting has been eliminated in a number of states. Same-day registration has been eliminated. That enables too many people to vote. Plus, serious voter ID requirements. You have to have a certain kind of identification with you. And in case you're thinking, some people say, well, what's the big deal? Everyone has a driver's license. Everyone has a passport. Who doesn't have a driver's license? Well, people who are elderly, often people who are disabled. There's also a tremendous correlation between poverty, people who are poor, who don't have cars, and race. So it turns out again that even if race isn't what was targeted here, if a legislature is trying to target people who were voting for the wrong people because it's the wrong party, there are all these laws, and the Supreme Court again has just declined to do anything about this. It's just, well, the states get to decide what their regulations are. So one thing that the ACLU has gotten into is community organizing, in addition to going to the courts, because the courts don't always work that well. And one of our current campaigns is called Let People Vote. We're supporting ballot initiatives to restore voting rights to people in Florida who have been disenfranchised because of a conviction, working with allies in Georgia to push for an independent redistricting commission, working to push back in various states the voter ID requirements and the election day, same-day registration. Okay, so there's voting, and you can again see, even if you look at a state like Wisconsin, and people say, well, Wisconsin has tipped, there are now more Republicans than Democrats. Well, I think you have to ask, why is that? Are people really being deterred from registering? Has it become too hard to vote for some people and not others? The final thing, when you start thinking about where we are in terms of with the pressure against dissent, the surveillance, the control of the electoral mechanism, if it feels like we're starting to look like an autocracy, the last thing that I want to talk about is that I think that another hallmark of autocracy, where we are now beginning to look somewhat Orwellian, is the instinct of autocratic governments to try to divide and conquer by demonizing people. So again, this started early on, 1798. There's this Alien Act where the president is given the power to get rid of people who are suspicious, who are dangerous. At the time, those were people who were believed to be connected with the French. And again, skipping to after World War I, because around that time, because that's when the ACLU began, a lot of people don't know about this, but the Palmer raids were a situation that happened when Attorney General Mitchell Palmer, who you see there, had a bomb explode near his home. So he rounded up all the people he thought should be suspects, and there were thousands of them, like 6,000 people who were just rounded up, kept in prison, many of them deported, and their offense was that they were from Eastern Europe and therefore were probably communists, or maybe they were Italian and therefore were probably anarchists, but just, kind of rounding up people and getting them out of the country. Okay, sound familiar? So one of the first things that President Trump did was to protect the nation from foreign terrorist entry into the United States by picking 7 countries and saying, people from there, we don't want you, and other kinds of things. The first injunction that the ACLU got against that law was on behalf of this man, Hamid Darwish, who is an Iraqi. He had been a translator for the American military. And he was a real hero. He had saved a number of American lives and was really a pretty amazing man. But he found that he and his family were getting a lot of grief from some of their neighbors in Iraq for having been so pro-American. So he went through 2 years of applications and vetting and process to move to the United States. Not an easy decision. And when he arrived at Kennedy Airport, he found that he was one of the first people to be picked up under the travel ban. He was not coming into the country illegally. He had a visa. He had gone through the process. But the travel ban said, just, no, go away. So we won the lawsuit on behalf of Darwish. There's another executive order that President Trump issued in the same week about public safety in the interior of the United States, which has to do with what we hear a lot now about. There was an article in the newspaper the other day about a 10-year-old who was in the hospital, and when she was finally able to be released from the hospital, the the immigration agents were right there arresting her because she wasn't documented, so she couldn't go home with her family. They wanted to deport her. They're in courthouses, they're just all over the place now, just trying to uproot, take anybody who doesn't have documents and find them. So one thing, which again, we'll talk more later if you want more details, but the states and cities do have a right because of the 10th Amendment of the Constitution, which says that the states reserve the rights that the federal government doesn't have. States and cities do not have to cooperate, they don't have to help, they can't keep the federal agents out, but they can refuse to pile on. So another thing that People Power has done is to shop around model ordinances to people all over the country to try to get new volunteers. We're now happily accepting all the volunteers we can get. and have people go to their local chief of police or their local city council, whatever, to try to persuade them to enact laws that will say, we're not going to be piling on here. If the federal agents come in, we can't protect you, but we are not going to be helping them by coming after people who live here, because we just think we can't do our jobs if we're doing that. So again, if you want to know more about that later, I'm happy to tell you. So, having worried you now with all the different things that are not only just a matter of individual rights, but really, I think, a kind of a threat to the rule of law, I think I want to end on a somewhat more upbeat note, because I think where we started with We the People turns out to be really something. So the thing that I find really encouraging is the people who are our allies in all this. You probably know that when the travel ban started, people were just spontaneously showing up at airports around the country, just saying, no, don't do this. This is not who we are. So this is one of the lawsuits, one of the 14 lawsuits that the ACLU has brought about the Muslim ban. And the second plaintiff who we have here, HIAS, H-I-A-S, anybody know what that stands for? Well, it stands for the Hebrew Immigration Aid Society. This is an organization that was founded in 1881 to help Jews who were escaping the pogroms in Europe. And their CEO, Mark Hetfield, says, we cannot remain silent as Muslim refugees are turned away just for being Muslim, just as we could not stand idly by when the U.S. turned away Jewish refugees fleeing Germany during the 1930s and 40s. Okay, so, what does this have to do with the Jews? It's empathy. Karin Korematsu, who is the daughter of Fred Korematsu, who you might know as the person who challenged the Japanese evacuation order during World War II in California, filed a brief in the Ninth Circuit case saying, don't do it. Can you please learn from our experience during World War II not to demonize people? For every one person who might be subversive or a terrorist, you are wrecking the lives of hundreds of thousands of people. So there's the Korematsu Center. There were, in the Ninth Circuit case, there's also this amicus brief that was filed by tech companies and other businesses to also say, don't do this. We have a lot of employees who are coming to this country, and we have an interest in this. And here's a list of some of the companies that just stood up to say, don't do this. This is not who we are in the United States, from Apple to Zynga. There were top evangelical Christians from all 50 states who signed petitions and letters saying, this is not Christian. And finally, just to show you something on the other side, here is a launch good campaign that was started by some Muslim activists to raise money to restore a Jewish cemetery that had been vandalized in St. Louis. So isn't this amazing, just people standing up for each other? So I think that if the Republic does survive, one reason would be that the we the people is the strongest element. And we the people do have to continue to take responsibility for what is happening here. So I will end by showing you, as a kind of a menu, the 14 different areas where the ACLU works, in case you want to talk about anything that I have not covered. But I want to say that the whole question of a republic, if you can keep it. I think there is some question now about whether we can keep the republic, but on the whole, I'm optimistic. So, thank you. With that, maybe I'll leave it at that.
Thank you, Susan, for your talk. Busy days for you.
Yep.
And the ACLU. You talked about the number of cases, 109 lawsuits. How many pending?
How many pending? Most of them still, because most of those are filed only recently.
Yeah. Busy times.
Yes.
Why now? This is interesting listening to you, and thank you for giving so much background to what we're seeing from afar here in Canada on some of these issues, the grounding in the Constitution. These sort of protections have been there, and there have been ways to bypass these protections as well. What do you think is unique about this time that we see this rise of authoritarianism?
Well, it's hard to say. In the United States, I think some of it was backlash against the election of Obama. Mm-hmm. And I think that the whole idea that the country was diversifying, and it felt as if we're on a track of being more inclusive, and there were just a lot of people who had a hard time with that.
Was it fear?
Part of it.
Were they frightened?
I think they were resentful. And there are a lot of people who really, what is true is that there are a lot of people who are suffering economically, who don't like globalism. They don't feel that they're doing well in the global economy. And they believe that their jobs are being threatened by other people, even though I think if you scrape down, it's really not true. It's not that people are trying to take other jobs in the coal mines. It's that we have industrialization, there's globalization. There are a lot of other forces, but I think there were a lot of people who were hurting and who wanted somebody who they saw as their spokesperson.
It's always hard to frame these sorts of questions because there's the immediate response and then there's the considered response. Do you know what I mean when you're talking about Trump? Like there's this desire to say something like, no, we're academics. They're laughing because we're all struggling. Why is it that the portion of the population in the United States now is willing to accept the easy argument that this isn't about industrialization, a new stage of industrialization or a new stage of capitalism? Why is it Obama? Why is it the people around the world taking their jobs? What's fueling that, do you think?
Well, again, what's fueling this? I think people say, why do people in the United States want Obama? People in the United States don't want Obama. By 3 million voters,
right.
He was rejected. And if everybody had voted, if we didn't have all this ridiculous, hard to vote, and election day is on a holiday, and you have to register, and it's hard, and you have to have a voter ID, and I think, if you had just kind of been able to poll everybody who is an eligible voter, I think Hillary Clinton would have won by a mile. Mm-hmm. So I think it's easy to overread what is the message here. And to me, one reason why I chose what I was choosing to talk about today is that I think some of this flaw is built into our structure. We appear to be a democracy, and it appears that whoever is saying what speaks to most of the American people is going to win, and it's not true, because of the Electoral College and because of the powers given to the states and because of the way they use it. So one reason why this happened, I give you a different kind of answer, is just a political answer. A number of years ago, the Republicans figured that out. And they started really putting all their resources into running people for state secretary, Secretary of State, the person who makes the electoral rules. And then they just started jiggering the electoral rules so they couldn't lose.
The gerrymandering you were talking about.
The gerrymandering, the suppression, just making it hard for people to vote who they didn't want to vote. Because what's a shame is that the Republicans have seen that the broader the electorate gets, the worse they do. Now, in some ways, that's the good news about the United States. Most people are perfect. They understand. It's not like they don't understand. So again, we have this core of 38% of the people or whatever who are willing to go with Trump, but the majority of Americans get it. And so again, the reason that Trump is president is not because most Americans like him. They don't. But it's because of the flaws that are built into our system, which we now can't get rid of.
Do you think the Republicans, who you mentioned, were sort of working the limitations and the loopholes within the Constitution to favor this kind of new regime? I think that's the best terminology I have for what you're undergoing at the moment. It seems like a new regime. Do you think they were surprised by Trump's election?
They may have been, but they sure have jumped on it now. As you know, there was complicated politics, and a lot of the Republican Party was into anybody but Trump. But many of them, as it turns out, are perfectly willing to go along with him, as long as they get the results they want. They want very conservative Supreme Court justices, and they already have one, and could get more than one. They want their tax policies. They did not succeed, and again, I think this is very instructive. They had the votes, technically, to get rid of the Obamacare, the Affordable Care Act, but in fact, when it came too close, people began to realize that it was going to hurt them, and it wasn't a good idea. So the politics are very complicated.
I have one more question for you before we open it up to the audience. You'll notice that we have microphone stands up here. If we, and the mics are on their way. That was one. The mics are on their way. If you have a question for Susan, please, if you can make your way to the microphones. We'd ask that the questions be questions and that they be concise. So that we have an opportunity to allow as many people as possible to enter into our conversation this afternoon. What do you think, with much expertise and a lot of insight into it, what do you think will be the legacy of this administration?
Well, I think that depends whether you're an optimist or a pessimist. I mean, one thing that has happened
Let's talk to the optimist view, and then we'll talk to the pessimist view.
Well, I think maybe the optimistic view is that people will learn that, that it does matter who's president. There are a lot of people who sat out the election because they think, oh, well, it doesn't really make any difference who's the president. I think people may be discovering that it does matter, and that participating in the electoral process is very important. I think the kind of the bad news is that I think that a combination of the coarsening of our dialogue, the president is just insults everybody. Somebody doesn't disagree with you, demonize them, insult them, just be vicious, and that's something that feels like it's kind of taking root in the culture. Mm-hmm. And what would make me afraid is if that that kind of outlasted him, if it turned out not just to be personal, but if people thought it was all right to be so polarized, so hyper-partisan, that the right thing to do is to demonize the other person instead of trying to find grounds of consensus. Because what I find, again, what's disturbing to me about the president is that most people who were elected toward an extreme of the people then start moving to the middle to try to be the president of more of the people. And Trump has not done that. He is not moving an inch toward the center, or not enough inches. And so if that becomes our political culture, then I think it's a real problem if people can't try to come up with legislation that is more representative of what everyone in the country thinks, and if we continue this hyper-partisanship.
Are you seeing the changes in the discourse in politics starting to enter into the legal field?
I don't know whether it's really entered the legal field yet, because lawyers have always just made the best arguments they can. Mm-hmm. But we'll see.
Yeah, the reason I ask that is I've been wondering a lot these days about the confusion of like and right under the new administration, how liking something or disliking something has become equivalent of it being morally right or morally wrong. Have you been seeing this as well?
I think from the point of view of law, what the courts are doing is not any different so far, although who the judges will be quite different. But what you're saying, I mean, to me, the case that we won this past week is very exemplary, I think, of what you're talking about the difference between rights and like. So you may be aware there was a 17-year-old girl who was in detention in a facility in Texas because she was a refugee. She had come into the country as an unaccompanied minor. And so the Office of Refugee Resettlement had prohibited her from leaving the facility with her guardian to go get an abortion. She had a right to have an abortion under American law, under the constitutional law, and under Texas law. And they would not let her guardian pick her up and take her to where she could get the abortion. They did, however, take her to a Christian counseling center where they tried to talk her out of it. And to me, that's just, that was just blatant defiance of the law, because it was what the Trump officials would have preferred that not be the law. And they're doing the same thing now with the Affordable Care Act. If they can't get rid of it, they'll just undermine it, and just to everyone's detriment. So I think it's a real issue of and it's not just like, it's power over right.
It's the notion of preference, taking precedence over.
Yeah, and the president says there are consequences to elections. I was elected, I get to do what I want. He doesn't get to do what he wants. The Constitution is supposed to be the last word, and they're now kind of digging into trying to delegitimize any anti-Trump force. So was it Jeff Sessions who just started to talk about the judges who were ruling against Trump because he's violating the Constitution? He's violating what all the cases have said. And they say, oh, well, these are just judges executing their own preference. Just like fake news, right?
Yeah.
If you criticize the president, it must be untrue.
Which raises all kinds of interesting questions about epistemology and politics at the moment. But I'd like to turn it over now to the audience, to your questions. Thank you. We're going to start right here. Good afternoon.
Hi, I just have a question, maybe your own personal opinion on it and the ACLU's stance on if there are any limits to free speech, or if the ACLU would acknowledge any limits to free speech. I'm thinking in terms of people like Richard Spencer, or what happened in Charlottesville, and what in Canada we have hate speech laws. And I just wondered what the sort of official stance of your organization was, and your stance on that is, because I know you obviously defended people whose views, as you say, you're sort of partisan in that way. But are there any limits, do you think, on that should be imposed on speech, or is it just everything should be allowed?
Well, I think the limits on speech are when speech starts bordering over into conduct. So things that you can't do under American First Amendment law, which I think is right, is you can say whatever you want, but you can't say things to incite other people to violence. It's like the old, you don't yell fire in a theater. Harassment is beyond the First Amendment. If you're targeting people and doing things that would endanger them in some ways. So there are a lot of limits to speech. There are things that you can't say. But to me, I think what you're alluding to is the ACLU does not believe that a limit to speech is based on what the content of the speech is. It doesn't matter what your viewpoint is, whether it's a noxious viewpoint or whatever. And therefore, we will defend white supremacists when they want to express their opinion. There was a 1934 pamphlet where the framers of the ACLU in 1934 addressed the issue of whether or not they would defend Nazis who wanted to explain their point of view. And our view was, yes, if they're just explaining their point of view, that's one thing. It's quite another thing if they're going to be demonstrating while armed. That's different. And we would support, as a condition of any demonstration permit, that people be required to leave their weapons at home. So there's a difference between peaceable assembly and violence. So certainly when again, it's not always easy to draw the line, but there is a line between the speech and violence. And I think that's absolutely right. I think there are a number of reasons why the whole idea of hate speech, hate speech is speech. And if that's all it is, it's speech that somebody doesn't want to hear. I think the way to deal with speech like that is not to silence it and censor it and try to pretend it doesn't exist, but to kind of get it out there so that you can answer it and respond. Otherwise it festers. Otherwise you don't know what you're dealing with. It might be more likely to then translate into conduct. And I would much rather know what somebody's point of view is to be able to take that on. I think that's true in the schools too. So I'll tell you, there was a survey that was done by UCLA a few years ago where they surveyed 140,000 entering freshmen who were entering in United States colleges. And they asked them, among other things, about their views of the First Amendment. And one thing that a supermajority said was they thought that their schools should be protecting them and keeping them safe against points of view that made them feel uncomfortable or threatened. The same supermajority, when answering the question, do you think dissent is important, said yes. Now, to me, those two attitudes are very hard to square. Dissent is usually something that makes people uncomfortable. It's a controversial viewpoint. It's the Barnett girls who didn't want to pledge allegiance to the flag. It's Charles Shank saying, the draft is wrong. Those things make people uncomfortable. And the fact that there are so many people who don't see the connection, to me, is a real problem. So, I think this is my personal view as well as the ACLU's view. You have to represent dissenting opinions. Sometimes we have to hold our noses to do it, because we are representing people who we totally disagree with their point. But I think that it is much better to let them make the point and let other people respond to the point in the public arena than it is to say, you can't say that. In addition to everything else, if you say that there can be a hate speech law, what you are doing is you are giving power to Donald Trump or the city of Charlottesville to say who can talk and who can't. Now, if you have a hate speech law saying you can't say things, however you define it, who is the city of Charlottesville and Donald Trump going to come after? Is it going to be the white supremacists or is it going to be Black Lives Matter? So, giving the power to the government to say who can speak and who can't speak, I think is worse than having people say their piece. And for all of us to try to learn how you respond to that. I'll give you one more example. There was a parade in New York City a number of years ago where the Ku Klux Klan wanted a permit to parade. Now, by, the time when this was happening, there were a very small and very elderly and bedraggled group of people. So there were like 47 of them parading down the street in New York City. And what happened there was that thousands of New York City residents lined the parade route with their own signs telling about why they thought that their ideas were utterly hateful and stupid. That, that's the way free speech is supposed to work. You talk back. You don't try to silence other people. If you think your arguments are better, you find the time and place and you talk back.
Is that part of your problem with what's happening in terms of fake news? If talking back is now called a lie.
Right. I think that is part of the problem. And part of the problem that we have is that everybody has a different news source. So it's very hard to have a conversation between the Fox News viewers and the MSNBC viewers when they don't see each other's news. So people have very different worldviews. There's a saying that we have that you're entitled to your own views, you're not entitled to your own facts. Well, these days it feels like everybody has their own facts, right? So I think it's a problem. So I think having it's hard to have one dialogue, but to me, there are places where we can still do it, and I think that the universities are a very important example of that. So for a place like Berkeley to take on, why do students want to not hear from Milo? Or why do they want to say, you can't invite this person, or we want to shout this person down? You take that on and start talking about it and talk about what you can do instead with hateful ideas. Be armed. Have your good answers to why what they're saying is wrong. And get your megaphones and do your own counter demonstration, and et cetera. Yeah.
Another question
Great,
here.
thank
Good
you.
afternoon.
Roberta Lexier, I'm from Mount Royal University in Calgary. I want to thank you for your talk today and for the work of the ACLU. I think it's important, especially now. I was going to ask a similar question about free speech and then also about the lack of reasonable arguments on either side. But I think I'll ask a different question instead about the sort of structural limitations that are being built into the system and how to get around or through some of those structural issues. So the politicization, for instance, of the appointments of Supreme Court justices, or the rights of the states to politically gerrymander some of their districts, and then the connection between those, that the Supreme Court is the one ruling on gerrymandering while the Supreme Court is a politically appointed group of people. So I guess my question is, how do we get around some of those issues? How do you fight them when the courts are going to be the place to do that, but they're now politicized, and dissent is being politicized and restricted in its own way?
Yeah, it's a great question. I mean, I think we do have to rely on the courts for something. I don't know the likelihood that the Supreme Court is going to do anything in this Gill versus Whitford case, but it seems to me it is the job of the courts to protect democracy. And when the people who are in power are really, kind of stacking the deck so that it's impossible to get rid of them, the courts should be really trying to, clean the blockage in the system. Now, what you say, of course, the justices are politically appointed, and I don't know if there's any way around that. The framers of the Constitution had thought of different ways to get Supreme Court justices, including they thought of maybe they should, choose their successors instead of having the president nominate and the Senate confirm. This is something that's gotten much worse in recent years, as I think you know. Antonin Scalia was approved by 96-0 in the Senate, because it used to be that the Senate had the view that anybody who was smart and qualified should be approved regardless of their politics, because after all, the president had been elected and was nominating, and that was the president's job, and the Senate's job should not be to look at the politics, but to just look at, was the person qualified? Well, you all know that fell apart with respect to Barack Obama's nomination of Merrick Garland. The Senate wouldn't even give him a hearing. So it's a change in recent years. We still have to hope that Supreme Court justices will rise above the politics. They don't always, and the best example of what you're talking about the politicized Supreme Court, was the Bush v. Gore case. Right, so here's this election that hinges on what is the Supreme Court going to say about all these complicated issues about hanging chads and how Florida counts ballots. And so the court ends up, all of the Republican-appointed justices take a position that favors Bush at the end of the day, and all of the Democratic-appointed justices take a position favoring Gore. So after that, I tried with my constitutional law class asking them the following question, without asking who they had voted for or supported. I said, so if you either support or agree with President Bush, and you would have voted the other way if the result that actually in law favors Gore, or if you support Gore and would have voted for the result that favors Bush, raise your hand and try to divorce the law from the politics. And 1 or 2 out of 100 would raise their hands. So it's not just the Supreme Court. People really saw the legal issues in the case through the lens of what favored their own political interests. So big problem. How do you rise above that? I think that's kind of related to what I was saying about the last question, because I think that what you have to do is you have to have a kind of a new sense of, we are reconstituting our republic again. And we have to have some sort of place where you could talk about what should the ground rules be. And to get people to agree that a fairer way to do districting is to have a nonpartisan commission instead of just whichever legislature is in power, stacking the deck, and then if they ever were not to be reelected, to go the other way. Yeah, I think it's very difficult. You look at a lot of what we have in place that's being a problem, and it's very hard to see any way that we can get the people of the country to rise above that and come up with more neutral rules that wouldn't favor either political party. So if you have any ideas, let me know.
We have time for one more question.
Sure.
Good afternoon.
Hi, good evening. I really don't know where to start. I live in Nashville, Tennessee, and as we speak, the Nazis are rallying freely in Shelbyville, Tennessee, while the Black Lives Matter movement has been criminalized.
Could you hold the
right?
microphone up? Please?
While the Black Lives Matter movement has been criminalized by the FBI. And I'm just a little bit concerned about some of the whitewashing of US history that I've been hearing here. None of the amendments that you've mentioned ever applied to black people, right? When the Black Panther Party tried to exercise the Second Amendment, the state of California changed the right to bear arms. The 13th Amendment has a clause that says if you're a criminal, you can still be enslaved. The 4th Amendment, people of color could get searched without a warrant any day. And it is a lie that the election of President Trump is about economics, because 64% of white men voted for Trump and 54% of white women. And Ta-Nehisi Coates has written about this, and many people have. White people across class and well-educated whites also voted for Trump. So this is about white supremacy. And the ACLU has this beautiful cooptation of the Black Power fist. But I'm interested in, sure, what do we make of the fact that people are being disenfranchised, they can't vote, so now we want to enfranchise ex-offenders, but these people shouldn't be in jail in the first place? So what is ACLU doing about the new Jim Crow, about the fact that the overwhelming majority of people who are in jail and on death penalty for no reason are there just because they are black and brown? I guess that is what I want to ask. I mean, are you collaborating with the Black Lives Matter movement? Are you listening to these, are you paying attention to what is going on? Or is this the WACLU, the White American Civil Liberty Union?
Okay, well, first of all, if you looked at our board of directors, it's incredibly diverse. If you look at our staff, they're incredibly diverse and large. And in terms of what we're doing, I don't have enough hours to tell you. Look at our website. One of our top priorities right now is fighting mass incarceration. I'm going on Friday to a conference at Berkeley about the future of criminal justice reform. We have a program that you wouldn't believe. It has so many different parts about fighting unequal sentencing, about fighting police misconduct and brutality. We are, as I just said, we're trying to get states to change their felon disenfranchisement laws. We have a racial justice project. We do so much work in the area. And a lot of people people say to me, well, why didn't I know the ACLU does that? Well, we don't control what the media reports. And the media still see us largely as a First Amendment organization. But we're not just that. I just showed you the list. We have 14 different areas that we work in. We haven't even gotten to all of our work about the transgender military ban and gay rights and women's rights. And we do a lot of other things. So I just think the premise that we're a white organization only defending white rights is just incorrect, factually. We do a tremendous amount of work, direct work. And our answer to what about Charlottesville, when people, including people on our staff, say, well, it doesn't make me comfortable that we are enabling white supremacists to speak. My answer is then let's double down and do more on the other side, which I think is exactly the premise of your question. And we are doing, again, not enough hours in the day to tell you, but look at the website, look at our message, it's called the Campaign for Smart Justice. And you would be incredibly impressed. For example, we sponsored a ballot initiative in Oklahoma, which took an incredible amount of work to get a direct vote by all the people, because the legislature wouldn't do it. And we got Oklahoma through coalition work and massive organization and politicking to change their sentencing laws. So what they're doing now is they're not sending as many people to prison because they've reduced the sentences for certain kinds of crimes, and they're reinvesting that money in alternatives to incarceration. And we've been fighting bail systems that cause people to be locked up because they're poor. So my answer to you is it's one of our top priorities. We are doing a tremendous amount of work on that area. So, again, if people have, I actually have one talk that I've given in the past called Myths About the ACLU. And, that may be one of them, that we're only a First Amendment organization and we don't care about racial justice. So I'm happy to tell you, not the case.
Susan, in my opening remarks today, I mentioned that you've been described as intelligent and committed, challenging, thought-provoking, generous, courageous. I'd like to add to that list after your talk today, insightful and fair and righteous in the true meaning of that word, in search of and the protection of rights. On behalf of the International Festival of Authors and the School of Liberal Arts and Sciences at Humber College, would you please all join me in thanking Susan Herman for her conversation today?
Oh, thank you.
Thank you.
Thank you all for being here.
They turned me off. There we are. And this is a small token of appreciation on our behalf.
Looks pretty large for a small person.
Yeah, it's heavy too. Careful. Weapon. Before we all head off, a couple of bits of housekeeping for the rest of the day. First off, copies of Susan's books are for sale up in the upper lobby, and she will be glad to sign them after this event concludes. For those of you who are here today who've joined us for our keynote event only, we want to thank you for coming and hope that you'll join us again for future Humber Liberal Arts at IFOA events. You can follow us on Twitter and on our website.